As Chairman of the Law Commission, I am very pleased to welcome you all to the Commission's fourth Leslie Scarman lecture. This lecture series was inaugurated by my predecessor but one, Sir Roger Toulson, in celebration of the Commission's 40th anniversary and in honour of our first chairman, Sir Leslie, later Lord Scarman. Our debt to Leslie Scarman, described by the first lecturer in the series, Justice Kirby of the High Court of Australia, as one of the most influential minds in the common law of the 20th century, is great indeed. And it's a particular pleasure to be able to honour him in the presence of representatives of his family who have been able to join us in the past and are here again with us this evening. The Scarman lecture takes place every 2 years. From the first, we've looked beyond these islands for eminent jurists of international reputation. In 2000, as I said, we welcomed Justice Kirby from Australia. In 2008, we heard from Professor Aaron Barak, former President of the Supreme Court of Israel. And 2 years ago, Justice Ruth Bader Ginsburg of the Supreme Court of the United States talked to us about judicial stimulation of legislative change. This year, we are delighted and extremely honoured that Justice Edwin Cameron has agreed to give the 2012 lecture on our behalf. Justice Cameron was first appointed a judge by President Mandela in 1994 and has been a Justice of the Constitutional Court of South Africa since January 2009. Prior to his appointment to the Constitutional Court, he'd served as a judge of South Africa's High Court for 6 years and of the Supreme Court of Appeal for the next 8 years. Before joining the bench, Justice Cameron was a human rights lawyer practicing in apartheid South Africa. He's received many honours and distinctions for his legal and human rights work. These include honorary fellowships at Keble College, Oxford, and of the Society of Advanced Legal Studies, as well as the Nelson Mandela Award for Health and Human Rights. He's also received a special award from the Bar of England and Wales for, and I quote, his contribution to international jurisprudence and the protection of human rights. Who better then to talk to us tonight about what can you do with rights? Justice Cameron has chosen this fascinating, highly relevant topic for us and has offered to take questions at the end before we break for a modest reception at the back of the hall. Justice Cameron, it's a great honour and privilege to welcome you here this evening. I now invite you to give the fourth Leslie Scarman lecture.
Good evening, ladies and gentlemen. It's a great honour to be with you. I won't try to do what I did one evening at one of the Inns of Court a few years ago, where I tried to explain to them that in South Africa we have an interactive opening with an audience, where you say, "Good evening, ladies and gentlemen," and the audience responds. I got a stony silence. So I'm sure if I say to you, "Good evening," you're not going to give me a stony silence back. Good evening, ladies and gentlemen. Good evening. I'm very touched and delighted. Many thanks indeed for that very generous introduction, Lord Justice Munby. It's a great delight and honour to be here, and it's a particular honour and a privilege to give the Scarman Memorial Lecture. I read up quite a bit about Lord Scarman, obviously, when I was studying here. I read many of his judgments, and I read Lord Justice Sedley's obituary. I read some of the other obituaries. I read the first lecture by my colleague Michael Kirby, who spoke a great deal about Lord Scarman. But the most touching tribute was delivered by someone a year ago in The Guardian. I'm delighted to see that Baroness Deitch is here this evening. She spoke about Lord Scarman as my legal hero. And she spoke about his tremendous humanity and his impact in creating the Law Commission, where he fostered her. She spoke most movingly about his impact on her career and her personal life, and also about his introduction of English lawyers to the concept of rights and the eventual enactment in the Human Rights Act in 1998, which of course he lived to see. And that takes me right to my theme this evening, which are rights. Rights are claims or entitlements. They can be useful things in language and in public debate, but there's long been skepticism about them. One needn't go back as far as Jeremy Bentham's famous description of natural rights as nonsense on stilts. His target was the notion of imprescriptible rights, namely those that aren't legally created, which he thought was nonsensical. More recent rights skeptics object precisely to prescriptible rights, namely those created by law. Some say, on the left, that the constitutional thought schema or rights consciousness are intended to secure the denial of desire in the face of contingency and the fear of loss by representing ourselves as legally compelled, and that in doing so rights merely create the reproduction of alienation, a condition of group membership. That's meant to be a joke, ladies and gentlemen, but it's too early in the lecture. No, someone really did write that. Less abstrusely, rights skeptics have contended that rights are simply too context-dependent or too wobbly and too woolly to be instructive about ourselves in the social frameworks that we live in, or to be politically useful in securing real improvements in people's lives. Whether rights should be entrusted to lawyers or to judges is especially controversial. In the High Court of Australia, Justice Hayden has recently denounced a piece of human rights legislation. This tasked judges with determining whether a law reasonably limits a human right. He said the language in which it did so was highly general, indeterminate, lofty, aspirational, and abstract. He didn't stop there. He said it was nebulous, turbid, and cloudy. The tasks it required judges to do, he said, were not tasks for judges at all, but tasks for a legislature. In your own country, Mr. Jonathan Sumption, QC, who has recently taken office in the Supreme Court. You were hoping I'd have a go at Lord Sumption, weren't you, ladies and gentlemen? Has charged that the European Convention on Human Rights has required judges to deal with the merits of policy decisions. In a democracy, he says, these are the proper functions of Parliament and of ministers answerable to Parliament and to the electorate. The Strasbourg judges, he has stated, regard the Convention not just as a safeguard against arbitrary and despotic exercises of state power, but as a template for most aspects of human life itself. For related reasons, some influential thinkers in my own country cautioned against including social and economic rights against government in our constitution. Their argument was that entrusting rights to judges instead of to the legislature alone would obstruct rather than help democratic transformation. To overemphasize the importance of rights, critics said, by introducing a battery of social and economic claims in a constitution is to place far too much power in the hands of the judiciary, which, however appointed or elected, is never as accountable to the populace as is the legislature or the executive, precisely Lord Sumption's reservation. Theorists have even argued that rights talk is affirmatively harmful to social progress. This is because it enables powerful groups to insulate privilege and to silence challenges by vulnerable sectors of society to existing social power structures. That critique has taken a particular form in my country, where the insulation of rights is said to have secured the insulation of racial power to the white minority. And a strong critique has recently come in South Africa from the Deputy Minister of Correctional Services, Mr. Nwaku Ramatlodi. In addition to assailing the conceptual fuzziness of rights in general, rights skeptics therefore emphasize the role of rights talk in masking entrenchment of privilege and power, and in deferring or diverting action for change. And they question whether rights can be useful to securing progress in society. And I must say, rightly so. It is a bad business to put too much trust in lawyers and the law. Doing so mistakes the value of legal regulation, which is not to plan or initiate social change, or to make public policy choices essential to it. It is rather to resolve conflicts and to protect against mistakes in the exercise of power by measuring public decisions against a framework of constitutionally entrenched values. To trust legal regulation and legal rights too much overloads the legal system. It may strain, crack, or even break under the resultant political and social burden. But if we accept the limited value of legal rights, if we accept that the law is an adjunct social instrument, that it cannot mend society nor choose its ways, and that its remedies and rhetoric should be approached with skepticism, if we accept all of that, then we may nevertheless defend a modest role for legal rights. It is this, that the law and legal rights can, despite rightful misgivings about them, play a practical part in securing what a decent society should promise to its citizens. What rights can bring lies not only in tangible goods consisting in bricks and mortar, but also in less tangible benefits that resonate in people's sense of well-being and entitlement. My argument is that South Africa's experience of democratic constitutionalism and the rule of law, and indeed of rights talk, over the last 18 years since the end of apartheid, powerfully instances what can rightfully be achieved with rights. Constitutionalism in my country has not been a panacea, nor has the jurisprudence giving effect to it been flawless, but it has secured some signal achievements, and these should be celebrated. To do this, in the next part of the lecture, I look at three aspects of our constitutional achievements over the past 18 years. I look at the role of legal rights in securing the material conditions of life. I look at law as a corrective of public irrationality. And lastly, I look at law as a determinant of civic dignity and moral citizenship. After considering these achievements, I reflect on what law and constitutionalism cannot do. But I conclude by returning to a modest reassertion of the importance of rights. First then, bricks and mortar, legal rights and the material conditions of life. The first democratic elections in South Africa were in April 1994. They took place under an interim constitution negotiated principally between the outgoing apartheid government and the African National Congress. South Africa's first parliament, functioning as a constitutional convention, then determined the final constitution, which was subject to review by the Constitutional Court, which had to certify the content of the constitution against previously agreed constitutional principles. Unlike the interim constitution, the final constitution contained rights to social and economic goods, rightly called subsistence rights. Apart from the right to basic education and the provision that no one may be refused emergency medical treatment, these entitlements are not absolute or immediate. They are impressed as rights to have access to social and economic goods. These include adequate housing, healthcare services, sufficient food and water, social security, and beyond basic education, further education. Given the intricate qualifications surrounding social and economic rights and the high hopes pinned on the transition to democracy after apartheid, the first rulings of the Constitutional Court on these rights were awaited with very considerable expectation. And the first two judgments of the court proved very controversial. The first was in November 1997, just a few months after the Constitution came into effect. The judgment denied a dying man access to kidney dialysis. He died soon after. The decision attracted extensive criticism, but the ruling was correct. The challenged health policy limited dialysis to patients with acute renal failure who could be successfully treated. The claimant's condition was irreversible. He was in the final stages of chronic renal failure. Dialysis would prolong his life, but giving it to him would deny it to others who had a better chance of survival. Though agonizing, the court could not have told the healthcare administrators that their policy was wrong. The second decision proved not much less controversial. Mrs. Irene Grootboom was one of a group of desperately poor people who moved onto private land to erect informal homes or shacks. But the land had already been set aside for formal low-cost housing, so the government moved them out. It was the middle of an exceptionally wet and cold winter, and they had nowhere to go. Emergency accommodation was not provided. In a unanimous judgment, the court refused to grant Mrs. Grootboom an order that government should give her a house. Instead, it declared government's policy generally unlawful for failing to provide for people in her condition. Hence, the court only granted a general order that declared that government's housing programs were obliged to provide for people in her position, namely for those who have no access to land, no roof over their heads, and who are living in intolerable or crisis conditions. It declared government's policy invalid to the extent that it failed to do this. Mrs. Grootboom died in August 2008, 8 years after this judgment. She was still living in a shack. It has become a commonplace taunt directed at the Constitutional Court that she died without a home. The litigation had failed to secure her a house. And the taunt is well directed. It is a humbling reminder to those of us who are in the business of law and constitutionalism that our craft has limits. But the judgment did not achieve nothing. On the contrary, it is now recognized as providing a productive seedbed for the court's socio-economic jurisprudence. It is conceded that it has multiple indirect material and symbolic effects. This has rightly received international recognition. But it has achieved far more than indirect, symbolic, and indirect benefits. The decision has had a direct material impact on many people's lives, perhaps many millions of lives. The nub of the judgment was to require the state to take active steps to create access to social services and economic resources for the most vulnerable in South Africa. To this injunction, government proved responsive. It enacted Chapter 12 of the National Housing Code. This is an obligatory guide that requires national, provincial, and municipal government to plan and act where people are in desperate need. The code itself calls the judgment in Mrs. Grootboom's case a landmark judgment, and it puts on record that a year after the judgment, the decision impelled national and provincial ministers responsible for housing to authorize a national program for quick action to relieve the plight of persons in emergency situations. The clear implication is that without Mrs. Grootboom's rights-directed litigation and without the court's declaratory order, the country's housing program would have continued to omit provision for the emergency needs of the poorest and the most desperate. More direct executive impact and outcome are difficult to instance. 11 years later, the practical implications of Grootboom continue to grow. The court of which I'm now a part has recently held that the same housing code requires local government to make emergency provision not only for people whom it itself evicts, as was the case with Mrs. Grootboom, but to make the same provision for those who are evicted at the instance of private landowners. This decision will have a very significant impact on the allocation of resources by urban municipalities. The court's socio-economic jurisprudence is far from perfect. Commentators have criticized its basic approach, which flinches from specifying that each of the social rights has a claimable minimum content. Critics have also bitterly denounced the court for refusing some claimants relief and for its reasons when doing so. From other commentators, the court's jurisprudence has elicited praise. The debate does not require resolution here. My thesis is much more modest. It is only that Grootboom and its progeny are a telling example of how rights-directed litigation can improve the conditions of a considerable group of socially vulnerable people in ways that would not have occurred without rights. These decisions show how rights claims can be practically translated into material improvements in the lives of the poorest. Mrs. Grootboom's death without a house does not mean that we should give up on legal rights. It means only that we should do better. I turn now to rights and public discourse. Rights can also achieve more ethereal, though no less dramatic, effects. They can change the spirit of the times. Wielding them can radically alter the terms and indeed the outcome of national debate on fiercely contested social policy. Differently put, rights talk and rights assertion can alter social discourse in significant ways. In 1998, President Thabo Mbeki plunged my country into a ghastly nightmare. The reason was his support for AIDS denialism. When he assumed the presidency in May 1999, the AIDS epidemic was cruelly corroding my country's life and health. In less than 10 years, the prevalence amongst women attending antenatal clinics had soared from 0.7% in 1990 to over 20% in 1999. The death toll was frightening. In 1998, it is estimated that 250,000 people died in South Africa of AIDS-related causes. I had close personal knowledge of death from AIDS since I had escaped it myself. In 1997, 12 years after being infected with HIV, I fell very severely ill with AIDS. But my judge's salary meant that I could take antiretroviral treatment. The result for me was momentous. From facing certain death within a median period of 30 months, my health and energy and vigor were restored to me. Little less than a year later, in 1999, I was so well that I could start campaigning publicly for the drugs that saved my life at very high cost to be made available to all on my continent. President Mbeki did not agree. From October 1999, he lent endorsement to a group of discredited dissidents who cast doubt on the medical science of AIDS. He repeatedly questioned the viral etiology of AIDS, the efficacy and safety of drug treatments for it, and the reliability and meaning of AIDS statistics. Worse, he refused to allow his government to distribute antiretroviral treatments, the only known effective response to AIDS. The effects were horrific. As hundreds of thousands fell ill and died, decisive government action was delayed for years in the midst of an absurd, obfuscatory debate. Conservative calculations shown and published in the Harvard Medical Journal show that more than 330,000 lives, what epidemiologists call 2.2 million person years, were lost because President Mbeki thwarted a feasible and timely ARV treatment program. This horror did not go unchallenged. The Treatment Action Campaign, founded to tackle the iniquities of drug pricing, was forced to turn its attention to presidential denialism instead. It did so unflinchingly. The Congress of South African Trade Unions joined it in challenging the president and in campaigning for rational policies and treatment. But their courage was isolated. Large sections of society were cowed into silence. President Mbeki was a forbidding man who headed a governing party with an illustrious history and a massive electoral majority. Many were fearful of crossing him. The issue, a mass epidemic of sexually transmitted disease in a country and a continent oppressed by centuries of racism, was explosive. As a result, most members of South Africa's political elite stayed mute. Business leaders were silent. Some intellectuals actively kowtowed to the president. Members of his party and cabinet, even those regarded as independent, refused to say openly that AIDS was caused by HIV. Even international diplomats were cowed. Out of fear, conformity, deference, or sycophancy, the establishment maintained an appalled silence, while activists and their allies struggled to persuade the president that his stance was ruinous. Their struggle was in vain. President Mbeki would not budge. In the gloomiest hour, the activists turned to the courts. They sought an order requiring President Mbeki's government to make available a cheap drug, nevirapine, that enabled pregnant mothers to halve the risk of transmitting HIV to their babies. Government vehemently opposed, but in December 2001, the High Court granted the order sought. Government appealed to the Constitutional Court. In an historic judgment, the court ordered government to make available nevirapine or a suitable substitute, available at public clinics to pregnant mothers who sought it. The judgment was a ringing victory for treatment access as well as for rational public discourse. As a simple matter of history, it was the pivot that eventually forced government to take decisive action in the epidemic. Albeit grudgingly at first, government eventually gave effect to it. Large-scale provision of antiretrovirals began in 2004, 30 months after the judgment. And today, nearly 1.5 million South Africans are living because of antiretroviral treatment, like I am, except that most of them are receiving it free from public clinics. This is the largest publicly provided AIDS treatment program anywhere in the world. Undoubtedly, it is the most significant material consequence of the decision in the TAC case. More even than Grootboom, that case materially changed the conditions of life for hundreds of thousands of people. It enabled them not to die. That, of course, is an important point, a bricks and mortar point, but it is not the point I want to highlight here. My point is that the assertion of legal rights and their vindication by the courts can fundamentally alter the framework, the terms, and the weight of public discourse. That in turn, of course, enables changes in material conditions of life. The decision in TAC, of course, had a dramatic institutional and operational effect, but it also had a discursive and ideological effect. 21 months before the TAC decision, the court had outlawed irrational job discrimination against those living with HIV. Its decision then in the Hoffman case had pointedly set out the medical facts of AIDS, even though the science was not in dispute. Despite these passages in the judgment, the decision was noted mainly for its effect in containing discrimination. Though delivered 11 months after President Mbeki's public flirtation with denialism began, the decision was not seen as rebuking it. There could be no similar ambiguity about the Treatment Action Campaign judgment. It was a rebuke not only for government inaction on AIDS, but for the absurd obfuscation that underlay it. That poor women had a legal right to use antiretroviral drugs to protect their babies from HIV transmission, and that government was constitutionally obliged to offer them the choice to take it, dealt a blow that would eventually prove fatal to the ludicrous discourse of AIDS denialism. President Mbeki had made his stand on AIDS an article of faith of his administration. He had proved impervious to anguished activist pressure, to international scientific entreaty, and to impassioned condemnation by commentators. But large sectors of the establishment elite, including members of his own party and of government, had maintained a cowed silence. By contrast, the Constitutional Court unerringly committed its moral capital to this issue. Its stand affirming medical science proved pivotal. Presidentially licensed denialism continued to dog the Mbeki government's response to the epidemic, but the court's authoritative assertion of reason proved a vital intervention that shifted public and governmental discourse in ways that eventually triggered effective action. The judgment constituted an authoritative, morally cogent, and politically irrefutable assertion of the science of AIDS and the necessity for public action in accordance with it. It showed the court as a source not merely of institutional decision-making power, but of unparalleled moral and intellectual authority. My retired colleague, Justice Cato Regan, has recently emphasized the importance of the court as a forum for reasoned debate on contested matters of public policy. The TAC decision shows the immense public power of that reason when rightfully employed. My last instance, ladies and gentlemen, is rights talk and moral citizenship. Rights and rights talk serve a further important function. They can confer the dignity of moral citizenship. Moral citizenship is a person's sense that he or she is a fully entitled member of society, undisqualified from enjoyment of its privileges and opportunities by any feature of his or her humanhood. It does not consist in mere freedom from criminal penalties and other legal burdens, but it is something richer, subtler, and perhaps deeper. It is a state of mind produced by the absence of criminal penalties and legal burdens. It is the sense of non-disqualification, of non-exclusion, and of positive entitlement that freedom from disqualification and from official sanction engender. If that seems impossibly abstract, let me recount to you my first experience of the heady sense of moral citizenship. It was Saturday, 13 October 1990 in Johannesburg. I was among a small band of marchers who set out on the first Gay Pride March on African soil. It was just 8 months after the apartheid government had agreed to negotiate towards democracy. The atmosphere of repression was still intense, but possibility was richly alive. And after some nail-biting ups and downs, we had obtained official sanction for our march. We made our way through a busy urban district, but had to cross a main artery leading from the city. It was 12 noon, and Saturday traffic was at a peak. As we reached the intersection, we saw an extraordinary sight. The police, assisted by municipal traffic officials, had cordoned off the crossing. Police vehicles with flashing lights barred the phalanx of vehicles to enable our small band, with banners and festive outfits, to march across the road. The business of Africa's biggest city was brought to a halt, while we clamantly asserted our entitlement to full citizenship in a future democratic South Africa. It was for me a moment of exhilarated insight, and it has never entirely left me. I had grown up knowing that I was gay in a society that despised same-sex orientation as a dangerous and unseemly perversion, and that suppressed and punished its expression. I felt deep shame at my feelings and desires, but worse, I felt shame at what I was, a homosexual. I deplored not being heterosexual, with the comfortable conformity, acceptance, and career and family benefits I thought that this entailed. I lacked moral citizenship in a society that would confer it on me only to the extent that I could pretend that I was straight. That the apartheid police could subdue the arterial flow of Africa's biggest city, even if only for a few minutes, to create passage for a demonstration for gay and lesbian equality, offered to me a glimpse of what moral citizenship could entail. And much of the Constitutional Court's achievement since 1994 has consisted in this somewhat intangible process of asserting the moral citizenship of all South Africa's inhabitants. This has been especially significant in a society that under apartheid owed its very existence to the processes of definition out, of exclusion, division, subordination, and condemnation. In declaring the death penalty unconstitutional, the court affirmed that the very core of constitutionalism is to protect the rights of minorities and others who cannot do so through the democratic process, even the worst and the weakest. Some of the court's strongest decisions have aimed at reversing women's subordination in society, in other words, in undoing women's legal disabilities as well as their moral disqualification from full citizenship. And the court has expanded the boundaries of legal claims to make it easier for women to gain recompense for violent attack In a country pulsing with xenophobic tensions, the court has confirmed that non-citizens illegally in the country can benefit from constitutional rights and deserve its protection. It has voided a regulation prohibiting foreign teachers from finding permanent employment in state schools. And it has found that non-citizens with permanent residence are entitled to claim social security benefits. In this task, the court is attentive even to the power of language in creating exclusion. Recently, in granting an order that declared a city-ordered eviction unlawful, it deplored the city's and the High Court's description of the occupiers as invaders. This, it said, detracts from the humanity of the respondents, is emotive and judgmental, and comes close to criminalizing them. On a continent and in a world in which difference has all too often led to destruction and bloodshed, perhaps the court's most persistent theme has been to assert the inclusive moral citizenship of constitutionalism. Its most vivid jurisprudence here has been in response to litigation by gay and lesbian activist groups. In a series of far-going decisions, the court has spelt out the meaning of constitutional equality and protection from discrimination for gays and lesbians. Its judgments culminated a few years ago in an order that gave the legislature 1 year to give full marriage equality. It is rightly pointed out that hate-filled attitudes and discrimination against gays and lesbians are still rife in my country. Lesbians in particular are sometimes targeted in violent attacks. Lesbians living in townships are especially vulnerable, for horrific rapes and murders have occurred there. The question that arises is this: what does it mean when a marginalized group, which for long centuries has suffered persecution and violence and oppression, is invested with full constitutional protection and equal rights? It does not mean everything, for by themselves, rights consist only in words. They cannot be eaten, and they cannot afford a shield against hatred and ignorance. But it also does not mean nothing. Lesbians and gays, like many others, continue to suffer injustice and oppression in South Africa. The path to non-discrimination and full inclusion still stretches long ahead. But much has been achieved. For nearly 18 years, gays and lesbians have enjoyed status as full moral citizens in South Africa, in a continent that elsewhere still treats their orientation with brutal and often murderous oppression. Not only have legal burdens been abolished, but inclusive protections have been enacted. Within the country, there's also fairly widespread acceptance that gays and lesbians are integral to the project of constitutionalism. This was strikingly asserted a few years ago when Mr. Jacob Zuma, then a presidential aspirant, appeared to make derogatory comments about gays and lesbians after the Constitutional Court's marriage ruling. One of his key allies, the then leader of the ANC Youth League, Mr. Fikile Mbalula, demanded that he apologize for his remarks. This was necessary, Mr. Mbalula said, because gay rights are human rights, and that is what makes our Constitution the most progressive in the world. And Mr. Zuma did apologize. He issued a statement apologizing unreservedly for the pain and anger his statements may have caused, and affirming his commitment to constitutional protection for sexual orientation. This was quite extraordinary. It illustrated the social power of rights talk. For what was at issue here was an idea: the notion that gays and lesbians are entitled to full moral citizenship under a constitution worth preserving, and to whose benefits they are equally entitled. That idea prevailed, and its triumph secured a victory for constitutionalism itself. Let me be precise about what I'm saying. It is that even when their realization is only partial, law and legal rights confer civic dignity, a perception of personhood, and a sense of moral agency on their beneficiaries. Despite grinding poverty and continuing dispossession and discrimination, The sense of moral citizenship and of civic dignity is widely disseminated amongst all South Africans. This internalized sense of constitutional agency is one of the most beneficial products of our Constitution. What the Constitution has conferred on all South Africa's inhabitants is a sense of themselves as bearers of constitutional rights, rather than just as legal subjects. This is not the same as material substance of equal protection and legal benefit. It is something different, but also precious. Indeed, in a world that too often mocks the dignity of humans and undermines their social agency, it is in itself a significant achievement. I have come to my ending. In some ways, what I have propounded is not only modest but obvious. It is that the law and legal rights can be human goods. And mostly they are. More than 35 years ago, the English historian Edwin Cameron, one of the finest prose writers of the last century, famously shocked his colleagues on the left by asserting that the rule of law is a cultural achievement of universal significance and that it constitutes an unqualified human good. But it is equally obvious that the law, while almost always better than no law at all, can also be used for great evil. My own country's history, where apartheid was enforced through minutely attended legal regulation, shows how pernicious ends can be attained through the law. Today in Iran and China, thousands are executed under cover of law. But as with many of his insights, Thompson saw something profound and important. It is that the law offers a framework for our better functioning as humans. The modest successes of constitutionalism in South Africa are the more remarkable if one considers how, without law, chaos, bloodshed and dictatorship seemed inevitable, but that with law we have achieved the small beginnings of a state of human dignity. Law cannot ensure that men, and they mostly are men, will not subordinate the instruments of power to evil, nor can it guarantee that they will not use them for illicit wealth accumulation. Law cannot stop corruption. It cannot engender human trust and affection and reliance. But what the law and legal rights can do, when invoked with creativity and with integrity, is to play a humanizing, expansive, and inspiring role in human society. The law can create the conditions for human flourishing. Through legal agency, even if applied imperfectly, material benefits can accrue to human lives. Legal rights can change social practice by altering discourse. And most deeply, when applied with a seemly blend of ambition and caution, of hope and humility, the law can lay the foundation for moral agency and civic dignity. To deny these possibilities in the law is to take too miserly, too cautious, and too crabbed a view of its potential and what we as lawyers and as judges can do with the law. The law cannot offer transcendence from human toil and human limitation, but it can offer us a chance to be better than ourselves, and that surely is something worth celebrating. Thank you.